Good evening, everybody. Hello, welcome, welcome. Good to see you. Hello, hello, welcome. Good evening. Hello, hello, hello. Yes, my cats. Oh, my cats are so crazy. They really are. They're crazy and we adore them. So we're very thankful for that. Very thankful. Hi from Massachusetts. Well, hello, 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 hello. Good to see you. Thanks for coming. Happy Monday, everybody. We made it. We made it to the end of Monday. So that's got to be good, right? Civics 101. Yes, that's right. We kind of do. Yeah, it's good to have a refresher on civics, I think, especially right now. Yeah, they are pretty cute together. They seem so, they're serious when they're playing, but they're not so serious that it hurts. Yeah, so Sarah, I saw, I was kind of holding my breath there because we had a moment where the judge came out. I'm sure you've seen it. I'm going to go back through and review everything, but where the judge came out and said, the jurors had their phones and were watching us on court TV. And I was like, what's happening? No, how'd that happen? But the judge wasn't playing because his attorneys say, well, can we go off the record to talk about what's going to go on the record? And she's like, nope, let's go. Yes, I know the hearing was wild. I know, I know. All right, everybody. So let me give you an update on the Murdaugh case. All right, we'll just do a quick. I'll spell it incorrectly, I'm sure. Murdaugh. That's not correct, but sorry. They had a motion for a new trial. So what they were alleging here was that the clerk of court in their community there had undue influence on the jury, and that there were certain things that Murdaugh. Thank you, everybody. Thank you. Here we go. There we go. We'll do that. Look at the top. Don't look at the bottom. Oh my gosh. Yes, diagrams. So he had asked for a new trial. They had had a preliminary hearing to determine if they were going to have a preliminary hearing to have a full evidentiary hearing. And so they did have an evidentiary hearing today to make that determination. And during that hearing, the judge came out and said, the jurors have been watching on the phone and they're not supposed to look at any evidence outside of what they get in the courtroom. So it was pretty bad. It was pretty bad. But the judge was like, the show must go on, and came back and said, nope, no new trial for you. We're not having any of that. Casey, it was juicy. Selfishing the coverage. Yes. I'm going to kind of wait until it gets processed, but I will be going through that. I thought they had an interesting point. I wasn't sure if it was enough or if it will eventually turn out to be enough, but you're kind of doing whatever you want, whatever you can possibly do for your client. So this was the Murdaugh case. This was a homicide case, and he was found guilty, but then there were some questions regarding the jury in the situation. Hello, Kristen. Good to see you. Miss Becky was so rehearsed. Oh, Sarah. Now, I read through the motion that Murdaugh's attorneys had filed with the subpoenas and evidence. We did a live on it, and it was just hilarious. I think I fell off my chair. It's fascinating. If you can remove the part that there are 2 losses of lives in a horrendous situation, if you remove that, the rest is really hilarious. What was happening. So yes, and of course he's already pled guilty to the money stuff, so there's that. But then there was this question on whether he was going to get a new trial. So hello, David, good to see you. So at least didn't fall off the. Yeah, I didn't fall off. Well, technically, I was actually sitting on the filing cabinet, but luckily I did not fall off. Did the Congress really get a subpoena today? So yes, they did. Now. I was looking to pull it, everybody, but right now the only thing that we have is really that clip where the Sergeant at Arms is accepting the subpoena. So I don't have the paperwork ready yet, But yeah, that's kind of a big deal. Kind of a big deal when a judge stands during a hearing. Oh, she was not happy. She wasn't. She wasn't very happy. Yeah, yep, the devil made me do it. Oh dear. Yes, well, VC, it's interesting because I was looking up different subpoenas, and a lot of times when Congress gets involved, they can do kind of like this standing announcement of it, but then it'll follow with paperwork. So I'm assuming that's what's going to happen here. So, oh no, if your connection's bad, I do recommend going out and then coming back in again. Usually I can tell myself if I'm in a really good spot as far as my mine goes. So it's hard to know what case it's, since there's so many. Oh, I know, right? It is. We're so busy here in the legal world. We're super busy. Oh my goodness. Yes. Sometimes the cash gets, I thought the retired judge was great today. Yeah, I was really pleased with the judge. I thought she did a good job. I will be going through that and kind of doing a summary of what happened, but it was very interesting. Very interesting. Looks good here. It's about blurring people in the videos. He realized, really? That's interesting. Yeah, there's a lot still going on behind the scenes when it comes to January 6th. There's still a lot left to be done. Who is paying his attorney's fees? Well, I mean, it would have to be him in some manner, but he's not probably making much at this point. But so there's been a lot going on. So let me just show you the calendar today, everybody. So we did have the Murdaugh evidentiary hearing today. So I'll just kind of add that in as an extra here. Now, technically, we were supposed to have the Massachusetts 14th Amendment hearing, but after pulling the most recent pieces of paperwork, it looks like all of their objections have been dismissed. So there was, to my understanding, no hearing because it has already been dismissed. Did Fani get a subpoena today? Now, that I don't know. That I do not know if she has gotten one. There is a lot of stuff going on with Miss Fani. So, I had a card actually that had the name. Oops, sorry everybody. It had the name, but I don't have it with me at the moment. My kittens were playing with it. But anyway, I did get this off of Etsy. I'll have to post. I should do a post. It was a shop here. So, I will have to find the card. Get it back from my kittens, but yes, Etsy is the place we go. So, did you hear the Sergeant at Arms received some subpoenas or something? Yes, I did. So when I get more information on those subpoenas, everybody, I will pull those and go through it. But if we have a general subpoena, I'm not sure exactly what the format is. You know, I was searching, but I had not found the document itself. So I did hear that it was announced on the floor that the Sergeant at Arms had accepted it. So it's just going to be a little bit of time, I think, before it's actually ready. Fraud amounts. Yeah, we don't know yet. We don't know on that. Fulton County had a data breach today. Most of the government stuff is at a standstill. Really? Oh, that's interesting. Oh, I hate to hear that. It's not like they're not doing anything there. There's so much. They're very busy. Appreciate organization and knowledge. Well, such that it is. Such that it is. It's about the Trump emoluments. Right. So the subpoena that was issued came from, I believe, the same committee that had issued the congressional report, everybody. So it was the Oversight Committee in Congress. And I had come on before, and it was this huge report where they came out and they said he had accepted, benefits or assets from other countries, which you're not allowed to do under the emoluments clause in the U.S. Constitution. And they found millions of dollars that he had received from various countries. So they went to subpoena more records from Mr. Trump. So that has been ongoing as well. So had ransomware they had to pay off a few years ago. It seems like a lot of people do that. Yes, Sue's excellent point. Yes, I only put public documents up here, and public documents that are free. Also, there's a lot of things you can get from Pacer and different other legal resources, but I only put up documents that I know everyone can find themselves online. So I do try to make sure that I stick with that. So calendar was empty at the first of the month. I know, and February's filling up too, everybody. Look at this. February is already starting to fill up. Yikes. So yeah, we have a lot going on. Now, so tonight, everyone, I am going to just do a synopsis of the 14th Amendment cases that are still green lights. Because again, Massachusetts has been dismissed at this point. Illinois is supposed to have a hearing. It was dismissed, and then the commission came out with a suggestion. So I'll go through a little bit of the commission. They're recommending removal. The commission is. They're not at the final stage yet. So that's in Illinois. So that's still going on. And then we have the final briefs for SCOTUS due for that presidential immunity case. The New York civil case opinion by Judge Engrong is also supposed to be due on Wednesday. So that's what's supposed to happen this week. And then we have an update in Florida. The government's response to the motion to compel is due in Florida, although I think they've already filed that, actually. I will be going over that. And then DA Willis has a response to the motion to dismiss, to disqualify her. Her response is due on Friday. SCOTUS came back early from their break to answer the ballot questions. Well, we're kind of in a time crunch. Oh, thank you, Estelle. That's so sweet. I appreciate it. And I do have to say, all of my gifts, I'm very thankful for everybody because it's my toner fund. And I was going through one toner cartridge a month, and now I'm going every 2 weeks. So I'm glad I have a very good recycling program here. Because I keep taking a toner and they're like, are you ready for another one already? I'm like, I know. So I'm very thankful for that, for my toner fund. I really appreciate that. Oh my goodness. Engrong said Friday. Okay, so he must have moved that then. Originally he had said the 31st. So if he's moving it to Friday, then we'll just be keeping an eye on it. I think keeps me, well, yeah, and there's a lot going on. It's, we've got Bannon too. We've got Sidney Powell. We've got the My Pillow guy. We've got a lot of different cases going on. And then the election interference cases. So it's very busy. Oh, my cat's got my pen. Oh my gosh. Oh, thank you, Toner. Yay. Thank you very much. Hold on, let me get my pen. Pearl was after my pen. Oh my goodness gracious. Yes, killing it with the oh, thank you so much, everybody. Thank you, yes, for the toner. It's a lot. And I'm just very thankful. I'm very thankful I'm able to print it out and go through it with everybody. So, yay, toner, woohoo. So, but that's kind of what our week's looking like. So I'm going to put here the New York decision, and I'm just going to put a question mark because we'll see if this comes through then on Friday as an update. What do you make of the subpoena to the House? Well, I'm just not sure yet, Jim. I'm waiting so I can see the paperwork that's coming through, and I'll do a full post. I will probably do a live on that either tomorrow morning or at some point, a pop-up live, a bonus one. So, do you have Venmo? No, I don't, actually, everyone. I'm so thankful for the gifts that everyone sends to me, and for anyone that subscribes. That is working out just perfectly for me. So I don't have any other funding sources, nor do I really need any. So, but thank you. I appreciate you asking. But nope, I'm in a good enough place. I love that pushing on FYP. Oh, really? Oh, that's fun to hear. We love that. The House was gone today, comes back tomorrow. Should be interesting on the floor. I agree. What about removing Trump's name from the ballot? So yeah, we're going to go through those cases tonight. So that's kind of what's on our docket. So let's kind of start diving in, everybody. Let me remind you all of where we've been and where we're going. Yes, we're still waiting for the DC Court of Appeals case. That decision should be out at any time, So the last two lives I did last week on the 14th Amendment were for the historical cases that were involved here. So let me just do an overview here, and then I'm going to dive into the cases that are ongoing right now. So we went through the 14th Amendment, Section 3, which is really what the issue is, right? We talked about the U.S. v. Burr case, which had to do with, enemies of the United States and what kind of evidence was needed. We also talked about the Griffin case, which will be brought up multiple times. This case was decided right after the Civil War with a judge who was still on the bench who had been part of the Confederacy. So the Supreme Court at the time had said Congress needs to go through and kind of pull anybody that they don't want first before we go through this. So those were the two historical cases that we went through, and then along with the language of the 14th Amendment. So we've been talking about that, but now that we've got our historical reference in place, it's time to start going through the cases that have been filed. So let me give you an overview of that. So let me see here. I have here. So there's several places that I go to check the status of what's happening with the 14th Amendment. There are several websites. The one website that I think is probably the most user-friendly, if you're interested, is the Lawfare website. So if you go to Lawfare, they have a disqualification tracking page. So disqualification, and they have everything listed out. They have a big map, and they have all of the filings. And what I've noticed is that they are the quickest to post. There are a couple of other websites that are tracking, but that one I found to be the most interesting. No, I probably won't turn comments off because it's going to kind of be a Q&A tonight rather than just reading through. So, but we'll see what happens. I beg your pardon. Oh my goodness gracious. So I recommend Lawfare, everyone, if you're looking for a website. There are multiples out there, but they did a pretty good job. So let me give you an overview. Yeah, we'll just see how things go. I reserve the right to turn off the comments if things get too messy, but yeah, these are interactive. Yep, exactly, VC, you got it. So basically, these are any state that has an outline has had some kind of a case on the 14th Amendment. So what's interesting, though, is that they're almost all from one person, Mr. Castro. So he has filed pro se in a lot of different jurisdictions. We have a total of 38 cases that have been filed. And out of them, most of them are this one person, and they've been dismissed. So if we're actually looking at cases involving attorneys, then those are the cases that are in green. So we have the Minnesota case, which was dismissed. We have the Michigan case, which was dismissed. Maine also here, which was an administrative piece, and that has been decided. And then Colorado and Oregon. So the newest cases that we have that have been filed and also dismissed, we have, okay, hold on everybody, just a second. I need to put the green over here. You probably can't see that very well, but we have Massachusetts here that was filed. Pro se means you're representing yourself. So you are your own attorney. And then here is Illinois. So we'll add those to the map. So we have Illinois, Minnesota, which has already been decided, Michigan, which has been decided. We've got Massachusetts over here. Maine and Colorado and Oregon were cases that This one has been dismissed too, but the big cases are Colorado and Maine that are still going. So Colorado and Maine still have eyes in the skies, but that's about it. So Lawfare is F-A-R-E here. Yes, so, yeah, thanks. Yeah, Rick can go. That's all right. Maine here. Hi, Sunny. Good to see you. So let me kind of walk you through some of these cases. So we had Montana, Idaho, Nevada, California, Utah, Arizona, New Mexico. Anything that's in pink was a case that was filed by Mr. Castro. Mr. Castro is an attorney, and he was the first one to file a lawsuit under the 14th Amendment. And he filed the first case in Florida. He filed it pro se, and it was dismissed. Now, he's filed multiple, any pink here is the same person, all right? He's filed multiple times claiming that his right to run as a Republican candidate is being infringed upon. So, that's not a winning argument, and he's not winning. So most of these are being tossed. So I'm not really putting into play any of the Castro cases with the exception of New Hampshire. So let's start with New Hampshire. I don't know, a couple $100. How much does it cost for him to file? I would say it costs a couple $100 each time to file each one of those. All right, so here's my folder. We will get into Colorado in a minute, but let's take a look at New Hampshire because New Hampshire is a bit unique, everybody. So this is the case out of New Hampshire. If you are interested in pulling the case, you can pull it here. And this case was filed by Mr. Castro, but I thought it was important because they set out this issue of a political question. So one of the questions the U.S. Supreme Court is going to need to answer is this issue on the 14th Amendment a political question? Because the court doesn't have jurisdiction over political questions. That's left to the other branches of government. So we have a memo that was issued in the New Hampshire case. So Mr. Castro filed in New Hampshire. This was a while ago. This was in October. And they went through this analysis of whether or not this case was a political question. And so we have a full doctrine that we use when we are going through a political question. Again, if it is a political question, the court can't hear it. So here is the test. It's the Baker test set out, and there are 6 elements. Can you make your map available on your profile? Whoa. I'm not sure. I'm not sure I can do that. Here you go. Screenshot. Thanks, Scooter. Screenshot, everybody. But if you go onto Lawfare, they have an actual interactive map. That's very much better than my map. So I would recommend that for sure. Take a screenshot. Yeah. I'll put it back up again, too, so everyone can get a chance to see it. But I want to take you through, hopefully everybody got it okay. Do you want me to put it back up again? I'll put it back up again. Here we go. I got to count this time to make sure everyone can screenshot it. So again, Lawfare has the full map up, and it's very, very helpful. For some reason, a lot of my colors don't translate very well online when I'm doing these. So definitely helpful to go to the Lawfare website. All right, so we're in New Hampshire, everybody. Let me go through what the test is for if this is a political question. This is something that the Supreme Court's being asked. They're saying, one side is saying this is a political question that needs to be answered by Congress. It's not judicial. But let's take a look. So in the Baker v. Carr case, the Supreme Court described 6 circumstances that can give rise to a political question. So as I go through each one of these, let's just figure out, is this Colorado 14th Amendment case, is it a yes or a no? So number 1, a textually demonstrable constitutional commitment of the issue to a coordinate political department. That doesn't make any sense. All right. So are the words themselves that are being used seem to correspond to a specific political agenda. How's that translation? Yes, that's right. Born to Bark. Yep. It's supposed to be the English version. I know. All right. So the language of the 14th Amendment is it in and of itself a political language? Is that the language? Hold on here. Where did I just put my? I just had my 14th Amendment here. So here's the 14th Amendment again. So I'll just read this first part. No person shall be a senator or representative in Congress or elector of president or vice president or hold any office, civil or military, under the United States or under any state. And then they go on further. But when we're looking at this language, is the nature of the language political? Nope. Kind of as an apprenticeship for Oregon. It's possible, Thomas. I've heard that Oregon has a little bit different rules. Oh my goodness. All right, so I don't know if the language is political or not. I'm unsure. So I would say, I don't know. Number 2, a lack of judicially discoverable and manageable standards for resolving it. So this means, have any cases made it to the U.S. Supreme Court or through different courts before on this issue? That would be a yes, because we've had the Burr case, kind of talked about it a little bit, but the Griffin case did, and then we have the case out of New Mexico too. So we've had several cases that have heard it. So this would be a yes. Or 3, the impossibility of deciding without the initial policy determination of a kind clearly for non-judicial discretion. So would it be impossible for us to figure out the language of the 14th Amendment if we didn't look back to what was going on at the time? This one I think is a little tricky. I think we do need to know that legislative intent. Or 4, the impossibility of a court's undertaking independent resolution without expressing lack of respect due coordinate branches of government. So if the court decides this, are they disrespecting Congress? And then 5, an unusual need for unquestioning adherence to a political decision already made. I don't think we have a political decision. Or 6, the potentiality of embarrassment from multifarious pronouncements by various departments on one question. So this language is ridiculous. I don't care about your embarrassment. So basically they're saying, are the courts, is everybody going to fight amongst each other if this court answers the question? So that's the test. If you're wondering what is a political question test, it is out of the Baker case. So many words. I know, right? So here, what the court is saying here is that the Baker court held, unless one of these formulations is inextricable from the case at bar, there should be no dismissal for non-justiciability on the ground of a political question's presence. So the defendants are contending that the claim here triggers the first Baker formulation, citing a number of cases. The courts that have considered this issue have found this textual assignment in varying combinations of the 12th Amendment, the Electoral Count Act, which prescribes the process for transmitting, objecting to, and counting electoral votes, the 20th Amendment, which authorizes Congress to fashion a response if the president-elect and vice president-elect are unqualified, and the 25th Amendment and Article 1 impeachment clauses, which involve Congress in the removal of an unfit president from office. So they're going through here again and just setting out what they think the situation is. So the weight of the authority has held the Constitution commits to Congress and the electors the responsibility of determining matters of presidential candidates' qualifications. So even though they did this political question analysis, this court in New Hampshire said, we have enough jurisdiction to tell you that the 14th Amendment Section 3 needs to be implemented via Congress. No, don't feel dumb. Don't feel dumb. No. That language is ridiculous. But the point we got to here is you're going to hear language like political question tests surrounding the Supreme Court. And so now you know what it is. It's a super wordy, complicated set of questions to ask to determine whether or not a court can hear a case. Why would they use simple words when there's 5-syllable words to choose from? True, I know, right? I know it. Oh, It's ridiculous, everybody. I agree. So in the Baker case, this was decided in 1962. So this is kind of just, middle of the road language even as compared to some of our other ones. Is there a chance the Supreme Court would make a decision on this before the elections? I think so. I mean, they're coming up on oral arguments in just 2 weeks. So I think it's absolutely possible. So that was the New Hampshire case, everybody, just to give you an idea. Now, New Hampshire set out, the one that we just spoke about, New Hampshire set out that it was Congress that needs to trigger the 14th Amendment. Now, the discussion of the 14th Amendment comes down to, is it self-effectuating? Is it what's what I'm looking for? I just lost the word. It was in my mind and now it's gone. Self-actuating. As soon as it was passed, it went into effect, or does Congress need to trigger it? Those are the two big questions on the 14th Amendment. For New Hampshire, they're saying Congress needs to trigger it. That's the question they had there. Now, the Michigan case, executing, yes. So we've got one saying Congress. Now let's take a look then at Michigan. Michigan and Minnesota are very similarly situated. So Michigan came out not too long ago, and they had an order here. We've got another set of attorneys that were involved. It wasn't pro se. And they were asking the Secretary of State in Michigan. And so what the Michigan court said was very similar to U.S. Supreme Court decisions after the Baker case. So we talked about that again, that political question doctrine that made no sense. Support an analysis that some questions fall within the doctrine, at least in part because of the related prudential concerns of causing chaos. So they're saying, I think we can discuss these kinds of things, but then they go in later and they say, what is an insurrection or a rebellion? Those kinds of nuanced decisions should be left up to Congress. So Michigan's decision said Congress needs to decide. So now we have two states saying it needs to be up to Congress because it's too complicated a question for administratively for them to do it. So that's Michigan, all right? So we've got New Hampshire here. We've got Michigan here. Michigan. And then we have Minnesota. Now, Minnesota, there is a full hearing in front of their Minnesota Supreme Court. And you can look it up online if you're interested in hearing the arguments. And they went in and they said, according to Minnesota law, this was their holding. Although the Secretary of State and other election officials administer the mechanics of an election, this is an internal party election to serve internal party purposes. And winning the presidential nomination primary does not place the person on the general election ballot as a candidate for president of the United States. And they have prior Minnesota case law. So there's no state statute that prohibits a major political party from placing on the presidential nomination primary ballot or sending delegates to the national convention supporting a candidate who is ineligible to hold office. Because there is no error to correct here as to presidential nomination primary and petitioners' other claims regarding the general election, which is not ripe yet because we're not at the general election yet, the petition must be dismissed. So Minnesota didn't say Congress needed an answer. What Minnesota said was that under Minnesota law, it wasn't ripe. The parties choose. And because the parties choose, they can choose a candidate that is not qualified. There's nothing in the law that says they can't. So that's how Minnesota chose to deal with it. Now, Michigan was similar, only that they also added in this additional element. So there you go. There's Michigan and then Minnesota. So those two cases have been sorted. Then we did have another one in Rhode Island, but I don't want to take too much time with that. So let's go into, we're going to I have another one in Rhode Island, but I don't want to take too much time with that. So let's go into, we're going to hit Colorado last. We have the Maine and Colorado we will hit last. So let's talk about these two cases. We've got two more. We've got two more cases here that were filed. All right, so we have this one, which is out of Massachusetts. So Massachusetts filed another objection as well. Being reviewed from, right, it's not very long. I know, you absolutely do count in Rhode Island. Rhode Island's got a very interesting history of making some serious waves. Nothing but respect for Rhode Island, but that case was filed by Mr. Castro. So I'm going to focus on the cases that were filed by other attorneys. Here, what's the name of those awesome folders that you use? I don't know. I don't know what they're called. Is this a weird folder? Is this new, everybody? Is this a weird I guess they're, what's this? I guess this is this. This is, it's Smead, I guess. I don't know. I use it because I prefer to have my files this way. This is how I've always done it since I was taking these into court with me. So I've always used these. This one, you can get them with 3 or you can get them with 5. But, you know, for me, it's always been nice because I need to color coordinate everything. They're law and financial folders. Okay. On sale at Walmart. Yes, I don't, Staples has them. Okay. We do the same files. Okay. I use this at work. Yeah, I just, these are just the files that I've used. They're pretty sturdy, so that's the other thing that has been helpful. All right, not weird, just file folders. Okay, yay! Yay for office supplies. All right, so in Massachusetts, we had another petition again. We had registered voters who set out this petition, again, wanting Mr. Trump off of the ballot. So they put forward a lot of the same arguments. They cited the Colorado case here. They also cited the Maine case here. So we have Colorado and Maine being cited. And so they're saying under Massachusetts law that he would also be disqualified, and he would be disqualified because of his actions on January 6th. Now, a lot of the language in here is very similar to the Colorado petition, like very, very similar. But when you get to the end of it, it's really all about how your state law is set up. Colorado has a unique law on their books that's been in place for, 100 years. And that was the law that they were using. But I don't believe Massachusetts has a law like that. So here they're asking the court to find that he's disqualified from holding office of president pursuant to Section 3 of the 14th Amendment, and order the Secretary of the Commonwealth to remove him as a candidate. Now, the update then out of Massachusetts is they took and reviewed the petition and came back. I'm trying to get everything here in place. Whew. Make sure I've got the right one. All right, so here is the decision that came back. So for the reasons stated in the attached statement of reasons, that's interesting, the objections are dismissed for lack of jurisdiction. So they went in here, we have a State Ballot Law Commission docket that's coming in, and they are saying we do not have jurisdiction. So let's take a look. In the above captioned matter, consisting of 90 pages, 3 large binders of accompanying materials were submitted for filing with the state ballot law on January 4th and January 8th, respectively. The commission's consolidating the matter. Each objection states that they're objecting to him being on the ballot, and then it says the objections assert the commission's statutory authority to hear this matter and render a decision is found under this section of the code. The commission, having reviewed the material submitted, has determined that the State Ballot Law Commission does not have jurisdiction over the matters presented. So jurisdiction is not being in the proper place here. And then we bump down to number 3. Even if the commission accepted the filings as objections and determined it had jurisdiction, the objections failed to comply with the commission's mandatory statutory and procedural notice requirements, thereby subjecting them to dismissal. The commission's statutory and regulatory provisions require notice of the objection be served upon the respondent and to every other party in the case, including all candidates for the office and any affected party state committee. And we're citing the different code sections here. In this instance, the certificate of service shows the objections were sent only to the respondent and not to other Republican presidential candidates on the ballot or the Massachusetts Republican Party. Indeed, the Massachusetts Republican Party, having submitted the name of Donald Trump to appear on the ballot, certainly should have received notice. Legal Dad made a point that both can be true, can be on the ballot but be barred from being in office. Absolutely. Yes, I agree completely. Yeah, Legal Dad has done some amazing posts on this. He is definitely on top of it. He's a great resource. Oh, thank you, Toner Fund, everybody. Thank you. So what they're saying here is we don't have jurisdiction, but even if we did, you didn't file your stuff properly. Oh my goodness, look at that. You didn't file your stuff properly. So because of that, we're unable to go forward. So Massachusetts is now off of the books. So we're outside of the parameters for Massachusetts. Not to say that they can't fix it and refile it, because they certainly could. But at this point, Massachusetts is out. So let's just take a look here, and we're going to put this one is out at the moment. So this one is out. Another one, by the way, that was out, everybody, was Oregon. Before I get into Illinois, let's talk about Oregon. So Oregon, again, every state has to file under their state law. So you have to go in and you have to take a look. All right, well, what are the election laws in the state of Oregon? So with Oregon, I don't want to get them mixed up with Florida. I have Florida and Oregon together. They have what's called a mandamus proceeding. So a petition for peremptory or alternate writ of mandamus or mandamus here. So what they're doing is they're asking a court to order someone to do something legally. Now in their petition here, they're saying that in Oregon, you need to file a request for a mandamus or a mandibus. They're saying their inadequacy of other remedies are not going to be working, so we don't have any other alternative means. The defendants, the Secretary of State, has the authority to disqualify Trump from the primary and general election ballots. State election law officials may enforce Section 3 of the 14th Amendment to the U.S. Constitution. That's what they're arguing in Oregon. They're saying that the state has the authority to enforce Section 3. The Oregon Secretary of State has the authority to enforce Section 3 of the 14th Amendment to the Constitution. So again, they're just following that up. The candidate filing a nominating petition must verifiably attest to being qualified to take the office. A presidential primary candidate selected by the Secretary of State must nevertheless file a nominating petition and verifiably attest to be qualified to take the office sought. So they have that qualification element. Nothing in the Solicitor General's letter excuses the Secretary of State from determining the eligibility of a presidential candidate. So that's their argument here. The Secretary of State may implement the disqualification by rulemaking or a declaration. So they're asking for that declaration. So they're coming in Oregon again, which I thought their petition was actually very, very nicely put together. Setting out again the different pieces of Oregon law that apply. So under Oregon law, these are the requirements to file a request here to have him pulled or not put onto the ballot. And then they're citing Oregon case law as well. So here's the 14th Amendment that they're citing. And then we have case law again that they're citing and different sections of Oregon state law. What has happened with Oregon, though, this has been filed, but it has been dismissed. And it's been dismissed here because they want to wait until the Supreme Court decides the issue. So hold on here. Where did my Oregon one go? Just a minute. Massachusetts is here, and this is, no, that's not it. All right, just 1 second, everybody. I'm gonna find it. Where's my paralegal? Help me. Oh my goodness. Let's see here. Well, it must have just gotten legs and run away. So I don't have it with me, or it's somewhere here on the table. I can't find it. We'll keep moving on though. In Oregon, what they said is we're dismissing this right now because we want to hear what the U.S. Supreme Court has to say. Because at the time that this was filed, we had a briefing schedule and an oral argument schedule set out by SCOTUS. So they said, let's just wait then. Let's see what SCOTUS has to say about whether or not states have that level of authority. And if they do, then we'll take it from there and go forward. But if they don't, then we'll have a better idea of what we need to do. So Oregon is out as well. So Oregon's dismissed because they're waiting on SCOTUS. So we've got Congress for Michigan. Minnesota says it's not time yet. We have Massachusetts, it's out. And then we also got Congress for New Hampshire as well. So then that leaves us with Illinois, Maine, and Colorado. So let's dive in. All right, so Oregon is off the table at the moment. Again, they could come back depending on how SCOTUS decides. So let me just put this back in here before I lose it. I swear my paperwork gets up and walks away sometimes, everybody. So let's take a look at Illinois then. Here's Illinois. This was filed with their state board of elections, again, as the state officers. We have, this was filed on the 4th, very similar situation to the other ones. We have statement of facts. Trump took an oath to uphold the U.S. Constitution, his scheme to overturn the government. So they're not even mincing words. They're actually overturning the government in Illinois here. He sought re-election but prepared to retain power even if he lost. Attempted to enlist government officials and illegally overturn the election. Trump urged his supporters to amass at the Capitol. In response to his call for a wild protest, the supporters planned violence, and Trump and his administration knew the supporters' plan to use violence or forcefully prevent Congress from certifying the results. So they are setting theirs out pretty clear. I think SCOTUS will address the general election too or stay within the primary. I think they'll take care of all of it. I think whatever decision they make will have to answer the question as to whether or not the state has that authority. And so if the state has the authority at the primary level, then whatever law in your state will prevail. But if you don't, like in Minnesota, if it's not until the general election and you can have unqualified people on your ballot, that's fine too. So if they're saying you just have to respect whatever the legislature in each state has passed, then that's the path you would follow. It'd be kind of mixed up, be pretty mixed up across the whole country. All right, so then we've got the insurrection set out. Again, this is Illinois. Multiple judges and government officials have determined that there was an insurrection. He acknowledged he was in command of the insurrectionists. He remains unrepentant. The Constitution disqualifies him, and he engaged in an insurrection, also gave aid and comfort, which is an added element. I've not seen this aid and comfort hashed out that way. I wouldn't say this petition is particularly well written. The Oregon petition I thought was very well done. I mean, it's not bad. It's just not, it's not the best I've seen. Colorado's was very, very good in Oregon. So then that takes us to, hold on here. Oh, that's Massachusetts. And New Hampshire. Oh, look, I found Oregon. There's Oregon. Oh, my gosh, now I've lost Illinois. Nothing but the best for everybody here. All right, so we're going to what I just printed out, and I can't believe I just lost it, everybody. Where did it go? The Illinois Election Commission has said that they would recommend removing him from the ballot. So that is what has just recently come out for all this. Oh my gosh, everybody. That's what came out of Illinois. And I would show it to you, but for some reason, I cannot seem to find it here. Michigan, New Hampshire. Oh, that's so frustrating. Where did I put it? All right, just a second. And this report had come in just yesterday. So, oh my gosh, I cannot believe this. All right, hold on, everybody. I'm printing it again. I'm printing it again. I can't live this way. I have to have the answer. So I'll go and check. I'll go and check my printer. Okay, well, we can at least start. I can't live this way. I have to have the answers. So here's the first page. Oh my goodness gracious, everyone. Oh, this is cracking me up. All right. So let's take a look here. We have, this is the Illinois case. Let's make sure that we're all on the same page. Multiple pages. Now we know the donor issue. I know. So we filed here motion to dismiss. So the candidate's motion to dismiss states it raises 5 grounds, but in actuality, the hearing officer from the brief recognizes 6 separate arguments raised for dismissal. So this is coming from the Board of Elections. Let me grab the last page. Well, almost the last page. I ran out of paper. We're close. We're close. So let's let's take a look. So there's a hearing officer report and recommended decision, and this is the Illinois case, all right? So they're going through the different grounds here. Illinois law does not authorize the board to resolve complex factual issues of federal constitutional laws, which is very similar to what Michigan had said. They go through the second ground, the third ground, and the fourth ground, fifth and then sixth. The final argument is insufficient facts have been pled to amount to an insurrection. Although this section is not mentioned, this is the functional equivalent of an Illinois code section here. So we have a motion for a summary judgment. So they're asking for it to be dismissed in a summary judgment. Candidate's motion to dismiss, and they go through and explain the schedule of brief and motion filings, expedited proceedings because of this section of their code in Illinois, which takes us to their findings, which is where I wanted us to go. So we have findings on the motion to dismiss. So the timeline for conducting a hearing and issuing findings is similar to the election code and Colorado election code. There's substantial differences, at least in terms of handling identical objections involving Section 3 of the 14th Amendment. In Colorado, a trial judge hears evidence at a hearing, while in Illinois, the board conducts the hearing, typically through an appointed hearing officer. So they go through again how different Colorado and Illinois law is, because Colorado really has something unique about their code. Here, they've got their own procedures that they're following. Now, the last piece here. In the event that the board decides to not follow the hearing officer's recommendations to grant the candidate's motion to dismiss, the hearing officer recommends that the board find that the evidence presented at the hearing on January 26th proves by a preponderance of the evidence that President Trump engaged in an insurrection within the meaning of Section 3 of the 14th Amendment and should have his name removed from the March 2024 primary ballot in Illinois. So they gave two options. They're saying if the board decides to go with the hearing officer's recommendation to grant the motion to dismiss, so they feel that it should be dismissed, that's fine. But they also say they need to look at that evidence and make that determination that an insurrection had occurred. So that's an interesting way that they've kind of split that. So again, to remind you, this is the Illinois State Board of Elections sitting ex officio as the state officers electoral board. And this just came out yesterday, this particular one. All right, so that's Illinois, everybody. Sorry I was a little bit late getting that out, but if you are interested in reading this whole opinion, which actually really isn't that long, when they go into a lot of the issues that we're going to be talking to the Supreme Court about, you can pull this up and take a look. All right. And then that takes us, everybody, to the final two pieces, which first we've got the Secretary of State's ruling in Maine, and then we have the Colorado case. All right. So at this point, I have covered all of the cases that have been filed by attorneys that have been decided. That was not a pro se case. That's it. There are no more lurking around. And you might say, well, Kansas and Oklahoma are highlighted. They did have a petition filed, but it was by Mr. Castro, and he voluntarily dismissed it. So we had Castro filing in New Hampshire, Vermont, New York, Connecticut, New Jersey, Pennsylvania, West Virginia. Virginia had a pro se person, North Carolina, South Carolina, Florida, Wisconsin, Texas, Oklahoma, Kansas, New Mexico, Arizona, California, Nevada, Utah, Idaho, Montana. These are all filed by the same person. So technically they've had a petition filed, but almost all of them have been voluntarily dismissed by Mr. Castro himself, or are on the way of being dismissed. The court dismissed it out of Florida, the court dismissed it out of Massachusetts and New Hampshire. So the big cases that we are talking about are Maine, we're talking about, so Maine here, Michigan, Illinois, Minnesota, Colorado, and Oregon. Those are the big cases, and Massachusetts, but Massachusetts has already dismissed. But those are the big cases, all right? So that's it. That's all of them. Probably dreading having to deal with this. Yeah, I don't doubt it. So the two cases that have held that he should be removed from the ballot, the first one is out of Maine, and they had appealed this case, just so you know. We had an appeal that went on, we would call it here, and this appeal was decided on January 24th, and what they're saying is that they are not going to take the case. They're not going to take the appeal because they recognize with the Colorado case going to SCOTUS, they're going to just wait until there's a definitive answer. So the main decision by the Secretary of State, this ruling is the ruling for the state of Maine at the moment. The appeals have been denied at this point because we're waiting on SCOTUS. All right, hopefully that makes sense to everybody. So what the Maine Secretary of State did, this was more of an administrative hearing. So the burden of proof, the procedures are different in an administrative hearing. You know, it's like if you go into the DOT and have an administrative or a work comp case, something like that. So the evidence was put on and presented in such a way, she did find that he had participated in an insurrection, and therefore he was not qualified to run. Because of those findings, and as the Secretary of State, she was saying he should not be on the ballot. But within this, she also said if it does get appealed, and it was, that his name would still technically be on the ballot until it's resolved. So better to say you shouldn't have been on the ballot but leave you on than take you off the ballot and you shouldn't have been on it. All right, so still on the ballot in Maine, if that makes sense. So Maine's was an administrative process, again, that has to do with administrative election law in Maine. And a lot of people think that constitutional law issues shouldn't be decided by an administrative person. But if you think about it, the Secretary of State is an elected position. So, you know, that's actually someone who's elected by the people, as opposed to the judges deciding these cases who are not elected by the people. So I can see lots of different arguments there. Next, we have Colorado, everybody. I have got so many posts that I've put up on Colorado. It took, I think, 3 lives to make it through the petition. It took another 3 or 4 lives to make it through the full decision. And it's a doozy. There are multiple parts to it, along with 3 dissenting opinions. And the dissenting opinions are quite good. I don't agree with them, but they're quite good. So these are all headed up to the Supreme Court. And basically the holding of the Colorado court is that there is a Colorado code section that allows for the determination of qualification to be put onto the presidential ballot. And because of this code section in Colorado, they've disqualified people before and used the same process to disqualify Mr. Trump this time. The big difference is that before we weren't dealing with things like terms like insurrection and applying a particular set of terminology to a set of facts that had occurred. So we did have a hearing in Colorado. It was a week long. We had the district judge ruling that the 14th Amendment Section 3 did not apply to the President of the United States. So the Colorado Supreme Court said, well, that's incorrect. That's not true. It does apply. But everything else you said was fine. What does it matter if a judge makes the decision? Well, it depends on how you view the separation of powers. Who should decide the qualifications for the president? Should it be Congress? Should it be the judicial branch? Should it be at the local, let the states decide who they want because they choose the electors. The state goes through their own process to choose electors for the president. So should it be the state, should it be Congress, or should it be the judicial branch? Those are the questions on who is the one that's supposed to decide this. So the Supreme Court is going to come in and make that decision. Who makes the final word on it? And then we'll go forward from there. So again, with the Colorado case, it was incredibly well written. It took multiple lives to get through. There were great points that were made on both sides. Both sides had excellent arguments. And this is the one that is now in front of the Supreme Court. So Maine is an administrative way of going about it, which a lot of states have. And then Colorado went through their election code because their election law there has been in place for a long time. So that's it, everybody. We've got Colorado is going up to SCOTUS, and then we've got the Maine case where they are waiting. They've dismissed the appeal, but without prejudice, so that it can be brought again after SCOTUS is decided. Also, Oregon is waiting on SCOTUS to decide as well. Minnesota is waiting for it to get closer to the general election. Michigan, again, thinks it should be up to Congress. Illinois, we don't know yet what's happening. That's still up in the air. Massachusetts has been dismissed. So that, my friends, is the current situation with the 14th Amendment. Maybe Colorado Supreme Court documents a lot easier to follow than many of the Trump documents. Oh, so true. Very true. Very true. Now, I've annotated it because this is going to be one of the biggest constitutional law questions for me to be witnessing. So I've made sure I pulled out and annotated everything. Oh, you probably can't see it. But just to make it easier, if you break it off into your different sections. So we have all of the subcategories here, all of the subdecisions, and then the dissents. I didn't make it all the way through the last dissent, but I feel it should be left to the states. Well, let's take a poll. Okay, I'm sure that can any of my moderators put up a poll whether or not it should be a state's decision or not? So should each state make the determination or not? That would be the poll. Can we put one up to do that? I can try. Thanks, VC. Yeah, just give it a go. Just give it a go. See if it works. Still have promise in the... Right. Am I going to be there? No, I'm not going to actually physically be there, but I will be listening. I will be listening. Can other states still file? Absolutely. Absolutely. You're meeting with your team to amend your case. Oh, great. Good luck for that. I really do. I wish you so much luck. Should be federal. The 14th is federal. True. In the primary, sure, but not a federal issue. Okay. The states. State decision. All right, let's go old school. All right, let's do this. So the 14th Amendment, Section 3, disqualification. Is it the states, up to the states, or should it be yes or no? So yes, it's up to the states, or no. So let's check it off. Here we go. Okay, federal, states. Poll is up. Okay. Woohoo! Yay, we got the poll. All right, federal. I'm still going to do an impromptu. Yes, no, yeah. Wow, we're like split here. Yes. No, yes. 4 minutes left. Oh my goodness. Okay. So this will be very interesting, everybody. Okay. Up to the states, up to each individual state. No, and I don't know. That's a fair answer. All right, well, we'll wait for the poll to go through. We'll see what the results are. But that's really the question, isn't it? I mean, when we've got these huge issues, the Supreme Court has been saying recently when it comes to lots of things that it goes back to the states. But what exactly goes back to the states? We will see. You don't see it? Okay. No, states on the ballot and holding office different. That's a really good point. So on the ballot versus holding office. So the one thing I would say with those two terms, which I think are a very important distinction, let's pull out that 14th Amendment language one more time here. Oh, where did it go? I need to. Hold on, I'll find it, everybody. Hold on. I'll get it. Where's the 14th Amendment? Where did you go? I know you're here. Let me see here. Oh, I found it. Woohoo! Okay, so the only thing is, with the 14th Amendment, something to keep in mind on Section 3 here is when we're talking about this removal of a disability. So the Congress can remove the disability. This is implying then that it already has happened. Now, it means that it happened, so it's already attached. It's already been executed, self-executing. So you are disqualified if you participate in the insurrection. And because of this language, I think that it would apply to being on the ballot as opposed to actually winning. Now, a lot of the legal scholars are going both ways. They're saying, oh, he should be able to be on the ballot, but can't hold office. For me, how I read the 14th Amendment is I feel that it is a self-executing, meaning as soon as the insurrection occurs, you're disqualified. And therefore, if you're disqualified, you can't be on the ballot, just like your age or citizenship. That's how I personally read Section 3. But there are two arguments for it. And I see the other side. I just disagree. So we will have to wait and see what happens. It's a very interesting legal exercise that we're going through with the 14th Amendment to try to figure out exactly the terminology. In reality, he's going to be on the ballot. It's going to come down to the votes. Now, whether he should have been kicked off of the ballot or not, again, I go back into my Tonya Harding moment where I say, well, if you would have taken her out of the Olympics and she would have won and she would have been found not guilty, she would have lost that opportunity. So Mr. Trump's like Tonya Harding, okay? So maybe he didn't do what he's been accused of doing. We do not have any guilty verdicts. We don't have guilty verdicts. We do have findings of wrongdoing in civil court, but we don't have any guilty verdicts for criminal court. So, but yet we do have a finding of insurrection from Congress, but they're not a legal criminal body. So is that the same? I don't know. But whatever happens, is it fair to pull him off of the ballot if he's found not guilty? Right? So that's the question. He should be disqualified for giving aid and comfort. Yeah, aid and comfort is really catching up a lot of people. And I can understand why. It's just when you're giving aid and comfort, those are specific terms. So aid and comfort, all right. So what exactly does that mean? Some people said, well, he's been offering pardons, but he hasn't given them yet. Or he says, we love you, but is that really comfort? I mean, I don't know. And the other thing is, are they enemies of the United States? And so each and every single person would have to have that determination. Are they an enemy or not? Are they an enemy or not? So then that poses my final question. Should never have gotten to this point. I agree. Moral support, but is moral support enough? I don't know. Calling them hostages. Yeah, but his rhetoric has that shock and awe flair to it, doesn't it? Because the more shocking your rhetoric is, the more attention you get. And there is something to be said for getting a lot of attention. The margin of error. Yes, I agree. They do seem like it. Not my enemy, but enemy of the federal government. Yeah, it's a tough decision. We've got legal determinations out there, and so we have to figure out which standard we're going to use. Yes, Colorado did, and Maine did as well. So both of those. Here's my final question, everybody. What happens if we get into DC? The DC case is actually going, and the evidence is on. What happens if the jury finds him not guilty? What's going to happen? If a jury of his peers sees the evidence presented and goes back and deliberates and comes back and finds him not guilty, what is going to happen? That's my question. That's the question I pose to you. Well, he's going to be on the ballot either way. Lisa, we have to accept it. Yes, that won't happen. It's right. Well, and we, the evidence is pretty solid. It could be a hung jury. Florida and Georgia, right? It's true. It's true. But right, we still have we still have Georgia and New York. And so let's just put them to the side though. All right, because this is going to be way down the road. Any significant situations when it comes to the actual election issue, we're talking about the DC case. But that's the question. Have your passport ready, unless the jury is full of Trump supporters. Well, that's the thing, everybody, that I'm trying to put this out there to just as a friendly reminder. Anytime you take a case to a jury, anytime you have a 50-50 shot. It does not matter how strong your case is. And it just doesn't. It's a 50-50 shot. It's a gamble every time. So if a jury comes back with not guilty in DC, then my question is, will everyone be able to accept that? Will be able to accept that the jury did their job, they did their civic duty, or are people going to go after the jury if he's found not guilty? So those are the kinds of things that you have to start preparing for now in case it happens. In case the jury comes back and says he's not guilty under the code sections in DC, I think it's okay to kind of run that scenario. Run that scenario in your mind. What happens if they say he's not guilty? Because we will have a fact finder listening to the evidence, applying the law, and making a determination. And our system depends on us believing in our juries, no matter what happens. So I think that's an important point to kind of stick to. Now, I've crossed off Georgia and New York because New York, it's a fraud case. We've got fraud going in New York. So if he's found guilty or not guilty of fraud, he's already civilly been found liable for fraud. So that doesn't seem like that big of a deal. He'll have a criminal fraud against him. And Georgia is a complicated RICO case, very complicated. The RICO statute is complicated. It's possible that, all 15 of these defendants could be found guilty, whatever. But that's going to be a fight the full way in Georgia. Now, the Florida case, everybody, is open and shut. That is the only case where I can truly see it's a very simple, or what I would refer to as a strict liability situation. Meaning, did you have classified documents? Yes. Were you supposed to? No. Did you give them back? No. That's the end of the trial. So the strict liability, the true federal case that seems like it's going to be the most open and shut, least amount of questions, is going to be the Florida case. So that's really where it's going to be at. Very complex, absolutely. Absolutely. But we have no idea what's going to happen in DC, everybody. We have no idea. I mean, DC is where this occurred. This is where everything is, all the jury's going to be pulled in. But if that jury comes back with a not guilty, it's something you should think about, something you should have in your mind. Judge in Florida case won't let it be heard till after the election. Perhaps, but it will still get heard. The Florida case will go on. It will maybe go extremely slowly, but the Florida case will continue to march on. And according to a lot of people, and honestly, in my opinion too, this it seems like probably the worst of all the cases, because this is where we're talking about espionage here. So this is more like your James Bond, like Dr. Evil kind of situation where, our secrets are being let out to everyone. So these confidential documents, classified documents, that's a big deal in the Florida case. Yep. So I just would put that out there. I'm not trying to upset anybody here, but I think we always have to remember that there is really no case with complicated sets of facts like these where you are absolutely going to win on it. Even though it seems like all the facts and everything, there's so much The evidence is overwhelming. The witnesses are overwhelming. This is an incredibly strong case, but there's still a chance anytime you put something in front of a jury that they could find the defendant not guilty. And if you can start to prepare for that now, then if it does happen, it won't be such a shock to the system. Yeah, I'm the very, very inexperienced judge on the Florida case. I agree. I agree completely. It's hard to watch. Portugal and Costa Rica for retirement. Oh, I love it. Well, I mean, yeah. If Trump was, he wouldn't even be. Well, true. Don't need to tell us. Tell that to. Oh, well, the other thing with that, Kyle, is, I feel like there's no way to control anybody's behavior. There's only your ability to control your own reaction to it. And so you just kind of give up at some point and just say they're going to do what they're going to do. But I, on the other hand, am not going to let it, destroy me. So I would say I hopefully am convicted of, and it would be remiss if I did not say how incredibly strong this DC case is, because it is. It's a 100-page indictment. It's with clear co-conspirators, with a ton of evidence. It's a very overwhelming amount of evidence to take to a jury. Yeah, he's been looking kind of, I can't imagine the amount of stress and awfulness that you would be going through to be facing, 4 different huge criminal indictments across the country. So, I mean, it's not just federal cases, it's not just state cases, it's both. And the defamation lawsuits too. Like, wow. And then the fraud case out of New York where he's going to lose his New York businesses. Like that, his whole world is absolutely crumbling in front of his face. It is crumbling. And this is only the beginning. This is only the beginning of it. The New York cases, everything is going in the order in which it was filed. So the fraud case was up first because it was one of the first cases to be filed, along with E. Jean Carroll. So then we're going to probably see the New York case next, because technically that one was filed next. So every single step down this road for this entire year, like, it's all gone. It's all crumbling. It's all crumbling. Right. He enjoys the chaos, true, but he also enjoys control. He has to have control over all situations. And this is not a situation that he can control. And the more out of control that it gets by getting different kinds of, findings from different courts, the harder it's going to be. I don't think his ego truly absorbs it. That could very well be. He may have compartmentalized in order to just be able to go forward in his life. But this is a tough moment. And, I'm not trying to stick up for anybody here. I'm all about, if you break the law, you need to be held accountable. If you do a tort, you need to be held accountable. If you do something wrong, you own it, you pay the price, whatever that price is, and then you go forward with your life. I will be the very first person to say that. But I also can acknowledge that he is an actual human being. He is a human being, and this has got to be awful. Now, he created this situation himself. He put himself here. So that's not a situation where I'm like, oh, I feel so bad. No, but I'm acknowledging for any human, this would be a lot. This would really be a lot. Is showing the toll on him. I agree. Are we sure he is? Well, I know it. And, I've always felt that we are only as good as the way we treat the worst of us. And I think that no matter what you have done, that there's a certain level of humanity in every person. That's my personal perspective on human beings. So I'm unable to take that element of being a human out of a human. So for me, it's sad to watch. I am definitely very pleased to see that justice is moving forward. We must have justice. But also, I can take a moment and recognize that, a human being is in quite a bit of a mess. Yeah, yeah. I mean, he's a human. He's a human. He's a human. That's what I would say. He's not an immortal monster creature. And I think E. Jean Carroll, oh my gosh, she did an interview on CNN and she said just the most amazing line that I think is just perfect. And one of the news people asked her, what was it like when you were sitting there on the witness stand looking at him and getting ready to testify in this case that's been dragging on forever and it's destroyed your life? And she said, I looked at him because she had lost sleep. She couldn't eat. She was so stressed out about testifying. And she said, I looked over at him and I saw nothing. I saw nothing because he is nothing. He is no one. He means nothing. And that I thought was incredibly profound for someone who in all of this has been damaged so severely to say, wow, I don't even have animus against him. I just don't even see him as a monster. He has no power. He has no control. He has nothing over me. And I thought that was amazing. I thought she did an amazing job. Yeah. I mean, exactly. Now, she went on to say, like the emperor has no clothes and the people around him supply him with clothes. And I thought that was, yeah, that's accurate. But for her to confront him in court that way is one of those moments, again, where we recognize that that person only has the amount of power that we give to them. Classes, oh, I agree. Interview this morning. Yeah, she's been doing a lot of interviews. Which I think is amazing. I can't even imagine going through an ordeal like this and then doing a media circuit and talking about it. She's been through therapy. Thank goodness. Thank goodness. I think therapy's good for everyone. Trauma is difficult. He did it to himself and it's a lot of tests for it. Yes, I agree. How can we see her testimony? So that I don't know. I've not been able to see any of the transcripts at this point. And a lot of times in cases like this, that information may not be made available at the federal court. Yeah, I would imagine that she would have. I mean, my goodness. She's on Rachel Maddow. Oh, good for her. Yeah, she is. Yeah, no, don't visualize it, Jim. No, move the visualization away. No, don't visualize it. No. Oh, we all need therapy, Scully. It's been a rough road. But we're going to do it. You do not think it'll be good if he's found not guilty. Well, yeah, I mean, I think that's something that you've got to consider. You've got to consider both sides of it. In the instance where he is somehow found not guilty, how are you going to process it? I think, yes. So Lisa, do we have the poll? Is the poll done? Okay, everybody, here's the poll. I don't know how to show it. I'm not sure how to show it. So let me just go old school, everybody here. So for this, we had 45.83%. And then for the federal, sorry, everybody, I was trying to say SCOTUS and federal at the same time. Federal, and I've only been drinking tea tonight too. We have 52%. Okay, it's at the bottom. Oh, so there we go. There is the poll. Here. I don't know how to make it show up there. Can we make him pay for national? I know, he needs to. I know. It's a tiny legal pad. It is. It's small, but mighty. So, and then we have the administration. We had administrative or executive was the third choice. Great poll, everybody. And we had a 2% on that. So it looks like the federal has won for our poll. So maybe that's where it should be then. We don't have a state-by-state situation determining that 14th Amendment. 52% to 45%. But we're close. It was real close. Can DC have a hung jury? Yes, absolutely, they could. It's a possibility. See why third party ruins things. Oh my gosh, BC, the accuracy. Oh my goodness. The accuracy. Oh my gosh. It should never be Congress. Congress is in a bit of a pickle at the moment, everybody. That's so funny. So at some point, hopefully, this is where we decide the rules. That's right. We decide it right here. Oh my gosh, that's so funny. All right, so I will be keeping my eye on this congressional subpoena situation. I want to get more details. So I'll be pulling who's filed what and how they filed whatever, so we can take a look at it very soon. Also, just to, let me get my calendar out. Oh no, where'd my calendar go? Oh my gosh, everybody, what has happened to me? Oh my gosh, where's my calendar? Where did it go? Oh, here it is. Just all over the place tonight. Oh my gosh, too much going on. Here we go. Oh, phew, that was a close one. So just as a friendly reminder then, this week we still have several things. It's the cats. I know. I blame the cats. I blame the cats. I know. Oh my goodness gracious. All right. So here's what we've got going. We have, so the Murdaugh case was today, yes. Illinois, technically the hearing is set for tomorrow. We'll see what happens with that. It might be kicked out. The last of the SCOTUS briefs then are due on Wednesday. And then we've got the New York civil case opinion may be out. Two paralegals. My goodness, Thomas. That's funny. Oh my gosh, funny and true. And they're sleeping on the job right now. So hopefully we'll see it on Wednesday, although there is talk that it will be out Friday. So it might come out Friday. So let's take a look. Thursday is open, and then we have Fani's response to the disqualification petition is due on Friday. Government's response to the motion to compel is technically due on Friday, but I think it's already been filed. And then perhaps that's when we'll see Judge Engoron. So as soon as the opinion drops for Judge Engoron's case, for the New York case, I will go live. So I will go live as soon as it drops. And then I'll probably do a couple of lives like I did with the Carroll case. So I'll do the live right after it drops to go through word by word. And then I will do an evening live to cover it again. So once that comes down. Also, as soon as that DC Circuit opinion comes down, I will be printing it and hopping on. So I'll probably do 2 lives. I'll do one live when it first hits and then one live in the following evening after it has hit. So those 2 opinions are the ones that we're watching for this week. So what time do they usually drop? Oh, it's all over the place. It's really all over the place. Yeah, too big for a single day. Yeah, true. I mean, that when I say that, I will have to take breaks for my voice. But I was able to I went through the Carroll verdict last night, and then I did do another live this morning. So as long as I have a big enough break in between, I should be okay. Yes, denied a new trial. I know. You do the best. Thanks always. Oh, thanks, Kyle. Oh, thanks. They're holding us hostage. Oh, I know, VC. I know. Yes, the Murdaugh homicide case. Yep, he was denied. So I will keep my eyes out on that, everybody. So we've got the subpoena. We've got 2 opinions coming in. And then, of course, once Ms. Fani files her response, I will be very interested to see that. So with that, everybody, I will sign off for now. As of right now, I'm not planning to be back on Tuesday, but I will be back on Wednesday for sure. But if something drops before then, I will pop back on again. So with that, I will say good night to everyone. Thank you so much, moderators. As always, I'm so thankful for your time spending that with us. So I'm very, very thankful. And everyone who could come and hang out, I will be back again on Wednesday, 7 o'clock Central Time. And of course, if something drops before then, I will pop back on again. So have a great night, everybody, and take care. I know things are really crazy right now, but we'll get through it together. So take care, everyone, and I'll see you Wednesday.